And before I hand over to Scott Garner, also from Rix Kay, let me just make a quick plug for the IoD for any non-members on the call in particular. So I've been a member of the IoD for several years, and I've drawn on the IoD for support in a range of executive and board roles. I've also completed the IoD's Chartered Director qualification, which I'm sure many of you on the call have also done, which is part of the IoD's continuous professional development program, and actually covers many of the topics we'll go through today. And I'd really recommended that. I mean, personally, I've benefited from a lot. But there's also access to the research facilities, numerous events like this one, which we're putting on in the South. And the IoD is great for the peer networking, and also obviously lobbies on behalf of business, and also gives access to the most impressive Pall Mall facility. So quick pitch for the Institute Directors. Thank you all once again for joining. I hope you enjoy the session and get a lot out of it. And I'm now going to hand over directly to Scott from Rix Kay to introduce the main session. Thanks, everybody.
Okay, thank you very much, John, and thanks for that introduction. I hope you can all hear me loud and clear. And yeah, once again, just thanks for everyone joining the call this afternoon. We've got a packed session, as John has explained to you. I just want to give a little shout out to Rix Kay, because I know not all of you will be familiar with the firm. Rix Kay is a full service law firm with extensive coverage through Kent, Sussex, and into Surrey, and reaches into London as well. We work with some large corporates in the Southeast and national organisations as well, providing the full suite of legal services to the directors of those businesses. And we also provide personal services to directors in their personal capacity as well, which I think a lot of that will come out in today's session, obviously through directors' duties. Can we just move on to the next slide, please? And one more. Thank you very much. I think John's already covered the speakers. I'd just like to thank everyone who's going to speak today, and I'm joined by my three colleagues, as you can see there. Kathryn is going to take you through statutory duties. Dan will look a little bit around personal liability for directors, and then Richard will finish off around insolvency. And we're really delighted to be having John Harte on the call with us today, Managing Partner of Integrity Governance. John's going to put all of the sort of legal do's and don'ts into context for you in real terms, and really talk about how you can, I suppose, implement best corporate governance on a day-to-day basis and in practice. So that'll be a really fascinating session towards the end. I'll leave the speakers to provide a bit more of an introduction themselves. So I think without further ado, we'll pass over to Kathryn. Just a reminder quickly before we do that to put your questions in the chat box, and we'll pick those up at the end. And I'll see you after the four speakers have done their bits. Thanks very much, and over to Kathryn.
Thank you very much, Scott. Hello, everybody, and thank you very much for joining us today. Thank you for donating your lunchtime to us. We're very grateful. May I move on the slides, please? So what I'm going to spend the next 12 or 14 minutes doing with you is to give you a brief overview of directors' statutory duties under the Companies Act 2006. And just to warm you up a little bit, to get you going, we won't do a poll question, but just to leave you a question for yourselves. Have you read your company's Articles of Association in the last 12 months? Next slide, please. Now, you may be asking why I've raised that question of you, and it's essentially because it's a fundamental duty of directors under the Companies Act 2006, which has been amended by, in particular, the Small Business Enterprise and Employment Act, but also by other legislation, that they have to act in accordance with the company's constitution. What the 2006 Act did was it codified that duty and a number of others, which have previously always been called fiduciary duties at common law. Now, those duties still exist at common law, but now they've been codified into the Companies Act as well. They find themselves in sections 171 to 177 of the Act, and we do definitely recommend that you familiarise yourselves with the provisions of those clauses, those sections. And that's what I'm going to take you through now. Next slide, please. A couple of general things to bear in mind before we start going through the statutory sections themselves. The Companies Act doesn't really distinguish between what type of director you are. So there's no distinction between executive and non-executive directors, trustee directors, whether you're a director of a public or a private limited company. As far as the Companies Act is concerned, you're a director. The duties do apply to de facto directors. Now, de facto directors are people who haven't been appointed as statutory directors, but nonetheless carry out the functions of a director. So just be aware of that. Since the Small Business and Enterprise and Employment Act, the duties also apply to shadow directors. Now, a shadow director is a person in accordance with whose instructions or directions directors are accustomed to acting. So just be a little bit aware of perhaps the person who sits in the background and calls the shots. Since 2015, that person is also caught by directors' duties, albeit they're not actually appointed as a director. The duties don't apply to professional advisors. So if, for example, you appoint a solicitor or a tax advisor or a corporate governance advisor, for example, that person can give you guidance and advice without being considered under the Companies Act to be a director of your company. Next slide, please. Okay, let's move into the sections themselves. We'll start at section 171, and that is that the duty to act within powers. So directors are obliged to act in accordance with the company's constitution. When we talk about a company's constitution, nowadays we're usually talking about its articles of association. But don't forget, it can also, for example, mean unanimous decisions of the shareholders that have an effect on the constitution. And when we're looking at older companies, so those perhaps incorporated before 2009, they usually have a memorandum of association as well. Directors can only exercise their powers for the purpose for which they're conferred. And when we're looking at the purpose for which those powers were conferred, so proper purpose or whether there's been an abuse of purpose, that's generally given a subjective interpretation. Next slide, please. Now, section 172, that's the biggie, I think. That is the duty on directors to promote the success of the company. Every director is obliged to act in a way in which they consider in good faith would be the most likely to promote the success of the company for the benefit of its members as a whole, which is a bit of a mouthful. When they're making their decisions, having regard to the success of the company, they've got to think about, they have to have regard to the factors set out in this slide here. So that is the likely consequences of any decision in the long term, the interests of the company's employees, the need to foster the company's business relationships with its suppliers, customers, and others, the impact of the company's operations on the community and the environment, and we'll come back to that a bit later, the desirability of the company maintaining a reputation for high standards of business conduct, and the need to act fairly as between the members of a company. Next slide, please. This duty, section 172, doesn't apply just to what you might consider to be formal decisions of the board, so taken at board meetings once a quarter or whenever you hold them. It applies to every decision every director takes all the time. And every director is therefore obliged to use their own reasonable skill, care, and diligence in having regard to that list of factors we've set out on the previous slide, which sometimes means taking external advice. So, for example, you're perfectly entitled to get advice in, guidance in, to inform your decisions. You might have an environmental issue you're looking at, but you're not an environmental expert. You can bring an environmental expert to help you in making your decision. The obligation on directors to have regard to the factors that we've set out on the previous slide is always considered to be subordinate to the overarching duty to act for the success of the business as a whole. Now that might change, and we'll look at the Better Business Act a bit later, but at the moment that's the position. Next slide, please. So when we're talking about success in this context of section 172, we're really talking about the long-term value increase for the company, so profit really. There are some circumstances in which directors are required to consider the interest of creditors as well, and Rich is going to look at that in a bit more detail later, because that generally is the case when a company is at risk of insolvency. There is also an obligation on some large and medium-sized companies to publish a statement setting out the ways in which they have had regard to that list of factors under section 172. So just be aware of the size of company you are and whether you're likely to be caught by that obligation. Next slide, please. Section 173, nice and easy. It does what it says on the tin. This is the duty to exercise independent judgment. Directors have to think for themselves. There are nuances, there are always nuances, and in particular in this case, the duty won't necessarily be infringed if a director acts in accordance with an agreement entered into by the company that restricts the future exercise of that director's discretion, or in a way authorised by the company's constitution. So the sort of situation you're looking at there is probably where a director is a nominee, for example, of an investor shareholder, that kind of thing. Next slide, please. So your next duty is the duty to exercise reasonable skill, care and diligence under section 174. And here there are two tests that are applied. The first is the objective test, which means that each director is expected to have the general knowledge, skill and experience that would reasonably be expected of any person carrying out the same functions as that person in relation to that same company. Then there's the subjective test, which is the actual knowledge, skill and experience that that director actually has. Unfortunately, the subjective test is the higher standard, so that applies if the director happens to be particularly skilled in a particular area. So you can't get away with saying that you're not really very good and therefore you're not required to hit the objective standard, because you are in all cases. So the best way that you can comply with this particular duty is to keep yourselves informed. Go to the board meetings, read the board papers, know and understand what is going on in your company. Next slide, please. Section 175 of the Companies Act requires you to avoid situations in which you have or can have direct or indirect interests that conflict with or might conflict with the company's interests. The obvious situation there is, for example, if you're a director of your company, but you're also a director of a competitor company. That's a straight slam dunk conflict of interest. Again, there are nuances, there are potential exceptions. So it's possible that conflicted directors could be authorized by the non-conflicted directors on the board, or if there's a conflict there, although nobody could reasonably have anticipated that that particular conflict would arise. So it'll come down to the facts quite often. Next slide, please. The next duty under the Companies Act is a duty not to accept benefits from third parties, and that includes bribes, unsurprisingly. The word benefit isn't defined by the Companies Act, but it's generally considered to have its usual dictionary definition. And I suppose what you're thinking about here is, for example, if you're in a tendering process, would it be appropriate to accept a trip to Twickenham to watch the rugby from a company that's entering into that tendering process with you? I know which way I'd decide there, but you have to make that decision based on the circumstances. Next slide, please. Section 177 requires directors to declare any interest that they have in transactions or arrangements that a company might be entering into before the company enters into them. And I think the thing to think about here for quite a lot of you is likely to be whether shareholder directors are generally interested. I suspect that a few of you are owner managers of your businesses, so you are both shareholders and directors simultaneously in your company. And then the question is whether shareholders should be declaring their interest as shareholders in the decisions that directors make. My view is yes. I don't believe it's possible for directors to take a decision that doesn't impact the shareholders one way or another. And therefore, I think it's prudent for shareholders to be declaring their interests as shareholders before the directors take decisions that impact the company. Other people have different views, but that's the way I prefer to do things. Next slide, please. Okay, one or two general things to think about now that we're through the sections themselves. Your statutory duties as a director will generally end when you cease to hold office. That isn't always the case. There are exceptions for the duty to avoid conflicts of interest, for example, and the duty not to accept benefits. One of the key things to bear in mind about director statutory duties is they are cumulative. You must comply with each applicable duty. So you couldn't, for example, say, because I was acting in good faith in what I believed to be the best interests of the company at the time, it was all right for me to be conflicted without authority. It isn't. You have to comply with each duty that applies. In every case, it's the company to whom you owe your duties. So not to the employees per se, not to the shareholders per se, but to the company, which is a separate legal entity. And I think it's worth always making the distinction between shareholders and directors. So again, I know that quite a few of you will be both at the same time, but they are different roles. You do wear different hats, and there are different obligations and duties legally, depending on which role you're playing at the time. So just be conscious of that distinction when you're making your decisions. Next slide, please. Now, I said that we'd come back to have a little look at the Better Business Act. It's not actually an act yet. What it is it's the name given to a coalition of over 1,000 UK businesses. And what they are doing is they are pushing for an amendment to Section 172. So that's that duty to take your decisions in what you consider to be the best interests of the company as a whole. And this coalition is attempting to encourage directors to be taking those decisions in a way that actively prevents harm or cost to society and the environment, as well as thinking about promoting the success of the business. So in essence, they're seeking to align the 3 Ps that we quite often talk about in business of people, planet, and profit. Should this become law, it's proposed that the amendments will be proportionate to the size and natures of a company's operations. So for example, if you're looking at packaging for your product, and perhaps the recycling packaging is 8 times more expensive than the non-recyclable packaging, you wouldn't necessarily be required or expected to take the recyclable packaging because that would be disproportionate in the circumstances. The reason I've raised this point now, when it's not yet statute, is it seems to me to be reflecting the mood music at the moment. So our view, our recommendation is that prudent directors should really already be considering those wider stakeholder interests, so society and the environment, when they're making their decisions. And crucially, recording those factors that they're taking into account when making decisions so that you've got evidence should it ever be required later on. Next slide, please. And that's me done for today. It really was a whistle-stop tour through your principal director's statutory duties. There are more. Don't think that that's it, I'm afraid. And Dan and Richard are going to look a little bit further at the consequences of breach and then also at directors' duties in particular situations like insolvency. Thank you very much for listening.
Dan, are you there? Scott?
Hi, everybody. Yeah, I think Dan was on the call. Let's just have a check. Hang on a moment. And apologies for the slight inconvenience. Dan is on the call. So Dan, are you there? Are you having difficulty? Okay, what I suggest we do is if we whiz on to Richard's bit, if we can just whiz through the slides, we'll come back to Dan. Hopefully Dan can get himself sorted out in the next 10 minutes or so, and we'll come straight back to Dan. So let's see if this works. Richard, calling you. Are you there?
Yes, I'm here.
Fantastic, thank you.
Yes.
Okay, I'm going to leave you to it, and we'll come back to Dan in 10 minutes or so.
No problem at all. Thanks very much. So just to quickly introduce myself, my name is Richard Ludlow. I'm the head of the dispute team at Rix Kay, but I specialise in insolvency. And so the point of today's talk is to just give you a few tips and points and issues that might arise as a result of your position as a director if your company is unfortunate enough to find itself in an insolvent situation, which I'm sure we all hope won't happen, but unfortunately sometimes does happen. So can I have the next slide, please? I didn't think it would be possible to get through a whole session without mentioning the word COVID. So I thought I'd get it out of the way right at the start. During COVID, you'll all have been aware from the news and reading the reports in the press that the government did an awful lot to put a hold and a brake, if you like, on the insolvency processes that companies use when other companies and individuals owe them money. Sadly, or not, depending on which side of the fence you're sitting on, as of the 1st of April this year, most things are now back to pre-COVID position in terms of what the insolvency impact is on companies. HMRC in particular have been particularly zealous in returning to the issuing of winding up petitions, and we've seen a large number of corporate insolvencies off the back of those petitions being introduced. And secondly, and something we'll cover a little bit later on in the talk, the insolvency service are utilising disqualification in situations where companies and directors have taken out bounce back loans and the coronavirus business interruption loan scheme loans and haven't paid those back, and the companies have then gone into insolvency. But more on that in a bit. Next slide, please. I wanted to give you briefly a kind of key sheet which had the particularly common types of claims that directors face if and when, unfortunately, their companies find themselves in an insolvent situation and have to bring in either an administrator when they put the company into administration, or a liquidator if the company goes into liquidation. And the types of claims that we see most of are claims for outstanding directors' loan accounts, wrongful trading, fraudulent trading, although that's not as common as the others, misfeasance, which is probably one of the most common, alongside directors' loan accounts, claims for what we call reviewable transactions, which I will give you a few more details on in a moment, and also director disqualification, which is on the rise, which is not a direct claim by the liquidator, but it is a claim that can happen as a result of insolvency of your business. And it is, as I say, on the rise at the moment. So I felt it was appropriate to give you a bit more detail as to what you might expect if you're unfortunate enough to find yourself in that situation. Next slide, please. So a director's loan account, I'm sure most of you on the call who are directors will be sitting there thinking, I've got a director's loan account. It is unfortunately one of the most common claims brought by liquidators or administrators when a company goes into insolvency. That is because it is effectively payable on demand. So they simply need to write to you and say, you have an outstanding director's loan account, please pay it. And that's it. There's very little else that is required to be done. The issue arises with directors' loan accounts on the basis of the large number of directors who, rather than paying themselves salary, generally award themselves pay by using dividends. And these will sit in the director's loan account until they're cleared. It's all fine if they're cleared, obviously, because that reduces the director's loan account back down to the amount that it was before. If they're not cleared and the company goes into insolvency, then they'll be sitting on the director's loan account. It's also not uncommon for directors to allocate and claim expenses for those things that they rightly incur on behalf of the business. However, again, they will sit on the director's loan account in most cases, and if the company goes into liquidation or administration, they will need to be dealt with. There are things that we can do in terms of balancing off your director's loan account. So it's not all doom and gloom, but it is something that you need to be aware of when you're going through your yearly conversations with the accountants, trying to clear that down as much as possible. Next slide, please. Wrongful trading. This scenario occurs if you as the director or the board of directors allow the company to continue to trade when you knew or ought to have known, and that's obviously a test that is implied by the liquidator and his legal advisors, that there was no reasonable prospect of avoiding liquidation or administration. At that point, if that is established, you become liable as a director or group of directors to pay the losses that have occurred after that date. So they have to establish that the knowledge existed, or that they can establish that you should have known at that point. Anything that any increase in the detriment of the company to creditors after that point, they will come to look at you for. It also applies to both shadow and de facto directors. It is not a requirement to be dishonest, and the company must have a net deficiency increase due to the continuation of trading. Next slide, please. Fraudulent trading. This is slightly more serious because potentially it carries a criminal sanction. Fraudulent trading is a case where if a director can be demonstrated to run the business with the intent to defraud creditors, so setting up a particular process that is likely to result in the creditors of the business being defrauded, then the liquidator can seek to bring a claim that is similar to wrongful trading, but has a fraud element and therefore has a criminal sanction potentially at the end of it. It's far more difficult to obtain the order. In my 20 plus years of doing this, very, very rarely have I actually been instructed to issue a fraudulent trading claim, simply because the ability to prove fraud to the level that is required by the court is much, much higher than a straightforward wrongful trading case. It does again apply to shadow and de facto directors, and it can capture anybody within the business who is knowingly a party to the fraudulent business. They can be asked to make a contribution back to the company's assets for the benefit of the creditors as a whole. Next slide, please. Misfeasance. This is a catch-all, if you like. During the course of the investigation that the liquidator or administrator will carry out after the process, if a liquidator, because it doesn't exist in administrations, if the liquidator going through the papers decides that actions which the director or former directors have taken have led to losses or breaches of fiduciary duty or other duties, then the liquidator can at that point issue a claim to recover that loss from the director. As I say, the claim can only be brought by liquidators, not administrators. It's possible for former directors to be liable personally for misfeasance, where they can show that action or misdirection or breach of duty caused loss or damage through those actions. As I say, applies to shadow and de facto directors and directors who have left the business but are still found to have been responsible for those losses. Next slide, please. Challenges to transactions in insolvency. These are the reviewable transactions that were covered on the first sheet. Transactions as non-value. This is where a liquidator or administrator makes an application to the court which can void the transaction if within a period 2 years prior to the beginning of the insolvency, the transaction caused the result of the transaction meant that the company was unable to pay its debts as and when they fell due. So you are in a position where the company is in financial difficulty or potential financial difficulty. It enters into a transaction at a value under that which could be identified as the true value of that transaction and causes the company to be unable to pay its debts as and when they fall due. Preference. This is where decisions are made that puts a creditor in a better position than they would have been without that preference. So normally it's a payment. So you are in financial difficulty as a business, and you as a director or board of directors decide that you want to pay this particular creditor rather these particular creditors. That would be considered or could be considered to be a preference payment, which would then be recovered by the liquidator if the company were then to go into insolvency. Next slide, please. Director's disqualification. So director's disqualification comes about as a result of insolvency of the business, but not directly as a result. So the liquidator of the business will be required to produce a report on the failings of the business. There's decisions that were made by directors, shadow directors, that led to, in their opinion, the failing of the business. This is submitted to the Insolvency Service. The Insolvency Service is a branch of government under the Secretary of State for Business, Energy and Industrial Strategy. They have an internal organization that reviews these reports and decides whether in their view, it would be in the public interest, which is the key test, to continue to investigate and attempt to disqualify the director from being a director for a period of time. Now, the period of time that they can look to disqualify you as a director for are between 2 years and 15 years, depending on the seriousness of the allegation and the evidence that can be provided to the court. Some typical allegations that director disqualification proceedings are brought on the basis of are non-payment of HMRC debt when you're trading as a business, abuse of the director's loan account, and a failure to maintain adequate books and records. There are many others, but those are some of the more common ones that we see. I should say in that point, more common up until the last 6 to 9 months, and we'll come on to that in a minute. The claims are brought in most cases by the Secretary of State, the Insolvency Service within the power of the Secretary of State, but they can also be bought by the official receiver. They can be issued in the High Court or the County Court. It doesn't really matter which. And it's important to also note, for all of you sitting there thinking, well, it's not fair. What about shadow directors? They apply to shadow directors as well. So anybody that's within the business that is found to have been made decisions that lead to losses or issues, and it's decided in the public interest that they shouldn't be a director anymore, they can be targeted. Next slide, please. As I said at the start of this presentation, in recent months, the Insolvency Service has been particularly targeting for recovery those directors who were involved in companies that have failed, mostly as a result of COVID, but in particular, those ones that have taken out monies via the bounce back loan scheme or the CBILS, the coronavirus business interruption loan scheme. We've seen a massive increase in those types of disqualification cases being progressed by the Insolvency Service, both from the perspective of the criteria that were used to apply for the loan, the loans that were then given, and the amount that was then spent on things which it's decided are not appropriate for monies that the bounce back loan scheme should have been spent on. It is also seen an increase in the use of compensation orders and undertakings. Now, compensation orders and undertakings are a relatively well-established process. They were introduced under the Small Business Enterprise and Employment Act of 2015, which I'm pretty sure Kathryn mentioned in her speech as well. And it allows the Insolvency Service to claim compensation for the decisions that were made by directors if there is evidence within the appropriate time period to bring director disqualification proceedings. They can then ask for a compensation payment on top of those director disqualification proceedings. This means you could end up being disqualified for 15 years, let's say, and asked to pay 100, 200, 300, whatever £1,000 it was, £50,000, whatever it is that's felt appropriate by way of compensation. Before COVID, they weren't massively used. However, since COVID and the government's attempts to recover quite a lot of bounce back loans and CBIL loans, they have been far more frequent. The other reason why they are important is because previously, before the introduction of compensation orders and undertakings was made more use of, very many directors would receive advice that because of the period of disqualification that the Insolvency Service was seeking, so 2, 3, 4, 5, 6 years, the easiest thing to do was to sign an undertaking which reduces the amount of costs that you have to pay in respect to the proceedings, and then make a subsequent application to be allowed to remain a director of a company during the period of your disqualification. However, if you are targeted by the Insolvency Service and they make reference to the fact they believe this is a case which is appropriate for compensation, then if you sign an undertaking in order to reduce the costs, you are effectively agreeing to the compensation payment. So these things now have to be given a lot more thought before you progress down the route to an undertaking. Next slide, please. The Insolvency Service not only use the CBILS and the bounce back loans and the compensation orders to attack directors. In recent months, and on the basis of COVID, they've also been given another tool to put in their arsenal, which is the Rating Coronavirus and Director Disqualification Dissolved Companies Act, which, as you'll appreciate, is not a mouthful at all. This was introduced during the course of the pandemic and basically allows the Insolvency Service to carry out investigations into the conduct of directors of dissolved companies. This wasn't the case before. So if, for example, you were a director of a company and you dissolved it, then there was no way the Insolvency Service had, despite what actions were taken prior to the dissolution of the company, to attack you for disqualification. That's now been changed. So if there is evidence when the company has been dissolved that it would be in the public interest to seek to disqualify you, they can do that even if the company was dissolved. And obviously can also go after you for compensation as well, if they feel it's appropriate. Next slide, please. So that, in a nutshell, is a very brief overview of the various issues that you can face in your company when it goes into insolvency, and a liquidator or administrator is appointed. The key things to do, if you're a director and your company's on the brink of insolvency, I've put it at the bottom of the slide, but the key thing really is take advice, okay, as early as possible. So if you are sitting in a board meeting and there is any suggestion that the company might be floating towards or going towards insolvency or going towards not being able to pay its debts or any of like that, take advice. Ideally from a solicitor who has insolvency experience, or from an insolvency practitioner, as early as you can. For two reasons. Firstly, because it will prepare you for potentially what might be going to happen. And the second reason is, well, three reasons. Second reason is, if you take advice, it may well be that we can do something about it so that you don't have to go into insolvency. And the third reason, and potentially as important as anything else, is it can be used in mitigation if you are approached by the insolvency service for disqualification. So if you got written evidence that you took advice, received advice, followed the advice, that will all help. In terms of the other things you can do, draw up a list of sources of funding and a financial timetable for funding levels to be met so that you can demonstrate the fact that you're taking this seriously. Keep a record of all discussions. Clearly, that should be done in any event, but if you are approaching insolvency, it's potentially even more important. Maintain regular meetings and minute them, obviously. If a company is listed or quoted, then please comply with the statutory obligations to disclose information as requested. Next slide, please. The things to not do if you believe your company is in a financial difficult state: don't allow new liabilities to be incurred unless you can consider them to be affordable. And in any event, make sure you minute the decision to do that within the board. So if you are thinking, right, can we afford to pay this new liability? Set out the reasons for why you decide you can and minute them in the board meetings so that you can actually point evidence that you've considered it, discussed it, and arrived at a decision. Avoid reviewable transactions, especially to connected parties. Wait for a creditor. Don't wait for a creditor to issue a winding up petition. Talk to the creditor, talk to an insolvency practitioner, make sure that you get the right advice. And don't, whatever you do, ignore creditor concerns or filing of accounts or presenting director reports, as they are all evidence in this whole process. And the last one, finally, although it might be something that you think is a good idea, don't resign and walk away, because it won't make any conceivable difference to the likely outcome for you personally, and it may end up affecting the business and putting them in a worse position. I'm pretty sure that's the end of my slides. I'm hoping that, obviously, if there are any questions, please put them on the chat and we can deal with them. I'm sure there will be questions. And obviously, if you want to contact me directly, then that's absolutely fine as well. I'm hoping that Dan is now sorted his...
I'm hoping too. Can you hear me?
Yep, you're there, and we can see you as well. That's fantastic. Right.
Eurovision, sorry.
So yes, and we've now got the Sevenoaks jury online as well. I will hand over to Dan. Thank you very much indeed for your time.
Thank you, Richard. Good afternoon, everybody. I'm sorry for being number 3 instead of number 2, but you can hear me now. So Kathryn and Richard have ably taken you through the issues. You're now more familiar with directors' duties and also with the do's and don'ts of when it all goes wrong for the business. What I want to do is to talk about keeping you personally out of trouble when your business is a going concern. So this is all about the next 10-15 minutes. It's all about trying to protect you, shield you from trouble. So let's crack on. So next slide, please. Right, the status. You are not personally liable for the actions or inactions of a company because of your status. It is because of your breach of your office duties. So that is a good thing. That general presumption will work in your favor. Use the company and following the rules as your shield. We've got legal personality of the company, as Kathryn said earlier on. It is a separate legal personality. It enters into contracts, as you're very well aware of. It can sue. It can also be sued. So that is essentially, that's your line of defense, your first line of defense against personal liability. Follow the rules, and the company will protect you. That's something to bear in mind. Moving on from that is it's well worth remembering. If you are a non-executive director, you are still just as liable as an executive director. So there is no difference there. Other positive things is, how can we shield you from personal liability? Well, D&O insurance, directors and officers insurance. I'm hoping most of you are familiar with the concept of the insurance. What really we're looking at is it's covering you against claims by regulators, shareholders, investors, and even creditors. Now, Richard did say about actions by creditors. Now, D&O insurance can, in certain circumstances, give you protection. This is not an all claims kind of insurance policy. There are limits. The best thing I would suggest you do is to look at the Chartered Governance Institute's guidance on standard terms and what you might want to look for. So D&O insurance, definitely worth having, but don't think it will get you out of every hole or trouble you get into. Moving on from that, we've got qualified third-party indemnity. Now, the company can give you indemnity against claims by third parties against you personally. These again are negligence, breach of duty, breach of trust. And again, I stress that this is claims against you by third parties. So that's something that you need to look into as well. Qualifying occupational pension schemes, that's a bit of a tricky one. I'm not going to get into the detail about pension schemes, but the reality is you're going to come a cropper if you're meddling with the pension scheme, and there's very limited qualifying protection you can have there, but it is available. So that's something you may want to look into. Next slide, please. Now, what we need to do is to look and explore the different ways in which somebody who wants to come after you personally will come after you. Now, what we're looking at here is we're looking at claims in contract, we're looking at claims in tort, which I'll explain, and looking at claims under statutory duties, and there's a few others as well, which I'll look at. So what we're looking at here right, so that it works for you, not just for the company. You may be the principal shareholder. This may be your wholly owned business, but essentially, sooner or later, you may have to consider selling the business, becoming a minority shareholder. That's when your status as a director is totally uncoupled from your position as shareholder, and you can be made liable for claims by the company. Now, they can come after you, or the company can come after you through your breach of service agreements, a breach of contract. So that's why use an opportunity, refresh yourself, look at your duties. If you don't want to or don't have certain duties, make sure it's explicitly stated so that they can't say that you have expressly or impliedly breached those duties for you to then go back and say they weren't mine in the first place. Use this opportunity, get the extent of the liability you are prepared to accept settled in that service agreement. Then you've got contract liability to third parties, as I say, trading disclosures. This is one I have seen before. A director was sued personally because they didn't on their website nor on their contractual documents make clear that this was a limited company. First of all, that there are fines, but also you can be sued under breach of contract because the contracting party who says that the company is in breach will actually say, well, actually, no, you're in breach. I contracted with you, the individual. I had nothing to tell me that this was a limited company. Again, come back to the point, use the company as a shield. And this would be a very good example. Misfeasance, Richard has touched on misfeasance. If you exceed your authority in negotiating a contract, It comes back again to the service agreement. If you've gone above and beyond the authority given to you, you can be liable for the element of loss that the company suffers and also the other side suffers for misfeasance. Entering into contracts prior to incorporation, that's another one. Well, you're personally liable. You haven't incorporated, so there's no such thing as a limited company that's going to save you here and act as the shield. Now, disqualified directors, and when you are acting under the instructions of a disqualified director, in both circumstances, don't even think about it, unfortunately, because you are going to be personally liable. That is a very strong one that they will come after you for. Fraudulent, negligent misrepresentation. If you're making claims which are not correct and you know it, or you're reckless to it, then you can be joined as a party to any claim against the company. So just be careful. Next slide, please. Liability under tort. Now, tort is one of these ephemeral things. What does tort mean? Well, essentially, it's not a contract. It's not a law. It's a common law thing. It's what has developed over many years that judges will apply. You have duties. You have responsibilities. And if you breach those responsibilities, then there are claims against you in tort. Quite often, what people will do is they will claim against you in contract and tort. And if one fails, the other one might succeed. What we're looking at here is, as I say in my slide very briefly, deceit. You can be sued for deceit, exceeding your authority. Now, the conspiracy one, again, these are quite exotic, I suppose, but there are still claims that can be made. If you act and conspire with the company to injure another party, if you are trying to take contracts away from another party and you do so with inside knowledge, for example, if you have data that you're using a database, you can be, and I've done this as well. I've made claims against a director because they have knowledge which they have gained from a special relationship, which tort allows me to go after them for personal liability, not just their company, but them personally. Negligent misstatement. This is one. It's similar to negligence, I suppose, but what it's saying is I'm making a statement to the world at large. If they act on it, and I knew they were going to act on it, I can be personally liable. So this is again, don't say things which are negligent, reckless, that are untrue, because you could be personally liable. So what I would always try and do is to make sure that everything goes through the company, that there is no distinction that can be made here. Everything is funneled through your shield. Again, I come back to the shield point of view. Next slide, please. Now, liability under statute. Now, Kathryn has gone through all of these. I'm just mirroring again in a very summary form the duties and the obligations that you owe under statute. Now, these obligations are owed to the company. Again, I come back to the point, whilst you are wholly owned, whilst the company is wholly owned by you, or you're a majority shareholder, or it's a family business, you might not think too hard about these things, but you should, because in due course, your liability can extend for 6 years. So when you sell the business, when you become a minority shareholder, the balance of power will change. You can be liable for acts which have caused loss over those years. So pay attention to these. These are duties that you have to comply with. Again, I would focus on two main ones. Now, they're all, as Kathryn said, you have to essentially act at all times for the benefit of the company. Every decision you make, is this the outcome that is in the best interests of the business? Secondly, am I exercising my powers correctly and for the purpose they were given to me? So you can't just say, well, I was doing what the business needed, so to hell with powers. That's not the way you can do this. You have to say, I'll do whatever I can for the business. The interests of the business are paramount, but I must act within my powers. I can't exceed them. And those powers, for example, you're not going to transfer £100,000 to a slush fund, a fund outside the business without due consideration. You may have the power to do that, but you don't have the purpose for which the power was given to you. Again, a lot of this is a morality situation. These statutory obligations came out of case law and common law, which says, look, we're going to apply a moral test to your conduct here. So there's no technicality about this. If it's not right and it doesn't morally it doesn't have a defense to it, you're going to be breaching these statutory obligations, and the company can come after you. Next slide, please. Other statutory liabilities, if you're making false statements in directors' reports, directors' remuneration reports, you are liable to the company for that. Again, this is something which you can have a legacy of many years, 6 years. Now, fortunately, shareholders and third parties, creditors particularly, they can't come after you personally. But what they will do is they'll sue the company. The company will then claim an indemnity against you personally. So by a back door, you will be personally liable. So be very careful about that. Health and safety breaches. Under the 1974 Act, Section 37, if anybody's really interested in this, if you are guilty of neglect, consent to breaches, or connivance in those breaches, then personal liability for health and safety breaches will attach to you. We've also got corporate manslaughter. Now, for many years, that was a law that was tried and tested and failed, but there have been prosecutions. So be very careful. You are not going to be able to say, well, you know what, to hell, I'm a director, I'm covered. You're not. Confidentiality. I'll move on to other duties of confidentiality, but there is a statutory duty. The 1997 regulations, what they are designed to do is to maintain the integrity in the company database. If you personally are misusing, or you are giving this database to somebody else, or you're making use of it for another company, then you will be in breach of the 97 regulations. So be very careful. Bribery. I hope that I don't need to talk about Bribery Act to anybody on this this discussion. But essentially, it's not just about accepting, it's also about agreeing to receive or failing to prevent. It's a catch-all situation, so it's drafted widely. Next slide, please. As I said, there are other duties. Now, I go back again. You can be sued, you can be pursued personally under contract, you can be pursued under statute, and now there is another one, which is fiduciary duty. I can pursue you under a fiduciary duty on behalf of a client if I think that your loyalty to the company has been compromised. And this is a separate claim. So essentially, it kind of is a catch-all. It's a branch of common law. I can come after you in that situation. You've been disloyal, breach of fiduciary duty, you've sold out the company for personal gain or for the gain of others, and there's a claim there. Again, duty of confidentiality, there's a common law right to come after you, not just under statute, but under this duty as well. As I say, there's health and safety at work and the corruption. So those are other duties as well. Bribery Act has enshrined some of them, health and safety likewise again. So be very careful. There is a wide variety of rights others can have to come after you personally. Next slide, please. Now the consequences. I won't touch too long on this. We haven't got much time, but essentially the remedies that a court has available, they can set aside transactions. They can claw back assets into the company that people may have thought they can take and they can dispose of and use elsewhere. Issued shares, well, personal liability for the consequences. The shares will not be cancelled. They will not be terminated. But there is personal liability for all the consequences that unfold. We have, as I've said, misfeasance. You can top up the liability of a company for exceeding your authority. And there are other remedies as well. There can be an injunction to stop you from doing things in the process, to actually compel you to take an alternative course of conduct, to give things back, and essentially pay damages to restore property, etc. So there is a wide variety of consequences. Next slide, please. Further consequences. Well, there is an element where if you have acted honestly and reasonably, but you are sued, and nevertheless there is strict liability, there is an element of sympathy the court can give you. They can grant some relief. That is very limited. I certainly wouldn't rely on it. Some breaches can be overcome. There are certain circumstances. Now, I should say, Section 232 of the Companies Act, it prevents a company from giving you carte blanche authority to ignore all of the duties Kathryn told you about. Simply can't do that. But in specific instances where there has been breach, a company can give you an indemnity. It can clear you of that wrongdoing under Section 180. Now that's very technical, so the time I have, which is close to exceeded now, really doesn't give me the chance to tell you about that. But essentially, don't go forward with conflicts of interest without declaring them. Don't go forward with transactions to related parties without declaring them, because you have to hope the company will cover you afterwards, and you don't want to have to remedy it after it's already happened and there's a claim available to somebody. Next slide, please. And my conclusion. Really what you have to do is just stay within the rules. I've jumped straight to the last one, but stay within the rules. Now, you also would be benefiting, as I said before about contractual, get your terms of authority, get your appointment under your contract regulated, get everything sorted so that the liability you're prepared to accept is codified, it's set out. So that's what you should do. Terms of appointment need to be clear. Document your decisions. At each step, take professional advice, take documentary evidence so you can prove what you did. Also, the factors that went into decisions. If there's a potential conflict of interest you weren't aware of, you can show the factors that went into that decision which were not that conflict of interest to try and head off claims against you. And finally, ensure you have the appropriate insurances that are available to you. Ensure you have qualified third-party indemnity. Always use this company and the arrangements you have with the company as your shield. That is a whistle-stop tour of remedies and how to avoid personal liability. And I hope it's been informative. Thank you.
Thank you, Dan, Richard and Kathryn. Thank you very much for setting the scene. I'm John Harte. I've been a director for over 20 years, a member of the Institute of Directors, and I work and run a business called Integrity Governance. We work with boards, company owners, CEOs to make sure their governance is effective. Next slide, please. So when we think about corporate governance, we've spent a lot of time really going through the legal rules and regulations, and Kathryn and Dan and Richard have really done a great job of setting that out for us. And that's one really important part of corporate governance: the rules, the regulations, the structures. Second thing I want you to think about in terms of corporate governance is all about how we bring our purpose to life. How do we actually bring that purpose? Is that purpose around generating profit? Is it around delivering outcomes in terms of well-being, in terms of services? But being really clear about the purpose of the company. And corporate governance enables that purpose to be brought to life. Third element of corporate governance I'd like you to think about is it's all about performance, the oversight, the accountability. What does good performance look like? What are the rewards we're putting in place for delivering that good performance? And have we got that interplay between strategy, risk, and return working properly? And that aspect of performance is really, really critical. Key element of the role of the board and of corporate governance. We sometimes forget corporate governance, boards of directors are populated by people. And people are a critical element of corporate governance. Our culture, our values are things that are important to us, but also that really critical element that serving as a board member is a leadership role. And as people, how are we leading? Fourth element of corporate governance I'd like you to think about is corporate governance is all about how is power exercised in the company? What are matters that are reserved for the shareholders? What are things that have been delegated to the board? How has the board delegated decision-making authority to do things to management? Are those delegations being followed? What's the hierarchy? What's the line of authority in terms of power being exercised in the company? Final elements of corporate governance I'd really like you to consider is the whole aspect of the role of the board, the role of good corporate governance is protecting the social license of the company, that community permission to operate. And good boards of directors should really understand the social license. What is the essence of that social license of your company? How is it being protected? How is it being nurtured? And we often understand and recognize social license when it's been lost. And you think of the erosion of trust in institutions, in companies, in brands that has occurred when social license has been lost. So a really critical area that's getting a lot more focus. Things to think about in terms of corporate governance. First of all, one size fits all doesn't necessarily work. It varies between companies. Secondly, corporate governance will vary as a company evolves, as you move into new markets, as you take on new areas of risk, or as you change the shape of the company. And finally, we need to recognize that community expectations, the expectations of our stakeholders, change. Sometimes it's reactive when something goes wrong, but sometimes we're navigating through the very dynamic forces of the expectations of our community. So really thinking about corporate governance above and beyond just the aspects of rules and regulations. Next slide, please. And we talk about the concept of the company. It's not a new concept. The British East India Company was established in 1600. It's the first time we hear about a company where we had a group of owners who put together their investment to share the risk and share the return. They appointed as their agents, hence we talk about the agency model, what was called a court of directors, the board of directors. And that board of directors had responsibility for oversight of management, accountability back to the owners, but also the future policy and direction of the company. And that's the corporate governance framework that we work in, the agency model, this social, legal system that we work in as directors. And just want you to think about, without going into the details of the documents that enshrine things that are delegated to directors and the separation between directors and managers, but this whole system relies on three fundamental currencies. And I'd argue that every single corporate failure you've read about or heard about, or where you've had a board that's been dysfunctional, one of those currencies at least has been in deficit. The first currency is trust. Do the owners trust the directors? Do the directors trust management? Does management trust the board? Second currency is respect. And the third currency is honesty. And in your work on and with and for boards, really think about, are you building trust and respect and honesty? Are you demonstrating that in terms of the way you work? Next slide, please. So a quick recap on some of the directors' duties and responsibilities. Next slide, please. As we've heard already, we've got two big sets of responsibilities. There's those fiduciary responsibilities, coming from the Latin word fides, faith. How would I expect you to behave if I put my trust in you? And Kathryn and Dan have really taken us through those duties in quite some detail. We also have our statutory duties, the laws of the land. And I've just got a couple here that we see, the top 5 that we see coming through in our board practice in the UK at the moment are listed here. But so as a director, we've got those legal duties, fiduciary and statutory. Next slide, please. But we also have what we call our director codes, the principles that boards can adopt and apply to ensure good governance. And the Institute of Directors Voluntary Code for Directors that was proposed and put forward in June is a really great starting point in terms of moving well above the basic minimum of compliance. That self-regulation that reflects best practice. It's far more flexible, it's less restrictive than legislation. For example, comply or explain or apply and explain allows us to take our best approach for our own company's individual circumstances, way above the basic compliance. So as a director, we need to think about, what does virtue look like above and beyond the basic minimum compliance? Really thinking about those directors' codes, the way things work around here. How is our board going to behave? And that might be enshrined in your code of conduct at a board level or in your board charter, which contains a code of conduct. But as a director group, thinking about our voluntary codes for directors, that's soft law, a real opportunity to move beyond the basic compliance. Next slide, please. One of the things to recognize in terms of governance is expectations are evolving. We constantly see changes in demands from the community. We've seen reduced trust in institutions and companies through a range of crises, from the financial crisis to other things. So that reduced trust generates change in demand from the community. increasingly there's an expectation of high level of director competence and propriety and increased professionalism. And one of the things to be very aware of is governance is often reactive rather than proactive. As sure as night follows day and invoice follows consultant, regulation follows a problem. So need to keep up with the legal developments related to our directors' duties. Next slide, please. When we think about the work of the board, I'd like you to think about the work of the board having 4 lines of sight. Next slide, please. The first one's oversight. We talk a great deal about that, the board having oversight. The next slide, please. The next line of sight is hindsight, looking back at what has happened. And one of the things that often happens when we have significant changes on boards is we lose that corporate knowledge. So that hindsight's really important. What have we learned? How can we apply that going forward? Next slide, please. The next point is insight, actually understanding the organization, the sector. And that's one of the reasons why one of the major issues we're seeing at the moment in the publicly listed area is a real pushback against directors that have too many commitments, that couldn't possibly have insight into the boards that they serve on. And finally, next slide, please. The last aspect of vision for a board is foresight. Actually anticipating what's coming down the line. What are the developments in terms of technology, politics, economics, having that foresight. When we think about strategy, strategy is where foresight and insight come together. Quick question for you to think about on your boards. How much of your time on your boards is spent on oversight and hindsight, which you really can't change a great deal of, rather than value creation in terms of insight and foresight? Next slide, please. Finally, good boards work through and with the CEO. If your board doesn't want to work through and with the CEO, you've got 2 choices. You either change your board or you change your CEO. Next slide, please. When we think about effective boards, we always look at 5 drivers, and this is something for you to think about in your boards. First one's role clarity. Does the board understand its role? Secondly is composition, all about the people sitting around that board table. Third is your board processes. And then deliberately here in green, the big human factors of culture and relationships. Do we have the right culture? Do we have the right relationships? Next slide, please. When we think about composition, we think about the balance. Have we got the right balance on the board in terms of balance of executives versus non-executives, independence versus non-independence, mindset, but also that balance of past, present, and future. We think a great deal about the role of the chair. She, he, or they have a fundamental impact on the leadership of the board and the effectiveness of the board. We also think about board size, not too big, not too small, adequate to do its work. Next slide, please. Last big thing we think about is diversity, demographic diversity, skills, experience, thinking styles, and circles of influence. And one of the critical elements to recognize is lots of conversation about diversity, but we need to move away from tokenism to recognize that diversity without inclusion is an illusion. So really getting the benefit of our diversity. Next slide, please. Our other key elements in terms of board effectiveness are our board processes, everything from information decision-making through to reporting, engagement with stakeholders, assurance, CEO and director, and risk and strategy processes. So making sure that those processes were effective. Next slide, please. And finally, we think about those elements of culture and relationships. Do we have a culture on our board that's effective? Or is our culture one of a get along and go along board that we never ever disagree? Or do we have a board that's a psychologically safe place for people to come and bring bad news? Or did we shoot the last messenger that happened to come with bad news to our board? If we did, we might not be surprised if next time people are a bit more reluctant to come to the board with bad news. So recognizing our culture on our board and also our relationships between board members, between the board and the CEO, but particularly between the board and shareholders and owners, and that most critical relationship between the leader of the board and leader of the management team are key drivers for board effectiveness. We could spend days talking about board effectiveness. We're out of time. Thank you very much for your attention.
Okay, great. Thank you very much, John. That was a fascinating insight into the actual practicalities of deploying and implementing great corporate governance in businesses for directors. And thanks also to the other 3 speakers, my colleagues, Kathryn, Dan and Richard. We've got a few questions to whiz through. Thank you for those that have been put forward in the chat. I'm going to pick those up. I suppose I'll take them in order. I guess that's probably the best thing to do. So we'll start off with a few that have been directed towards Richard. I think these are all around insolvency. Let's begin with Simon Lee. Thank you for your question, Simon. This one is for Richard. Yeah. Does disqualification on shadow directors prevent them from only being titled as directors or shadow directors as well? And if so, how? Richard, are you on the call still? I hope you are.
I am, yes. So if you're disqualified as a director, effectively what that means is that you are prevented in the eyes of the Insolvency Service from being involved in the management, promotion or formation of a company for the period of time that you are disqualified for. So regardless of whether you're a director listed at Companies House or just somebody who is used to sitting in the background, if you are disqualified, if you are found to have been involved in the management, promotion or formation of a business in the following period of your disqualification, then you are subject to potential fines as a result. So both potential further disqualification and also potential criminal sanctions as well. Hope that answers the question.
Great, lovely. Thank you, Richard. I should just point out if people do want to pick up with more detailed questions or circumstances around personal issues that they have for their own sales or their companies, then obviously all of the contact details will be on the slides. We'll get those over to you. We've got 15 minutes or so to whiz through the other questions. So I think we've got time to cover most of these. The next one again is for Richard, I think, from Brian Foss. Thank you, Brian. In a situation where the company has not provided accounts, so has been delisted from Companies House, how can it then be moved to insolvency without a stakeholder paying significant legal fees? I'm not sure Richard wants to answer anything that doesn't involve legal fees, but anyway, over to you, Richard.
So if I think what you're saying is if effectively you've not filed your accounts at Companies House and the company's then gone into insolvency, I think that's what you're asking. Effectively, the actual act of not filing accounts and insolvency would be an issue that both a liquidator and or administrator and the Insolvency Service would pick up on. So there would the question of cost, I guess, if you're saying why would we then be expected to pay money to redress that balance, it would be looked at after the event. The issue with director disqualification is not necessarily what you do to remedy the situation after the event. So for example, I'm asked repeatedly, there was a debit to various creditors when we went into insolvency. I'm being approached by the director disqualification unit at the Insolvency Service. If I pay that money back, will it all go away? The answer to that question is no, because it's not the result of what you do that counts. It's the actual action in the first place, if that answers your question. If it doesn't, my apologies, please give me a call and we can have a chat and I'll do my best to answer it then.
Great, and I think one more for you, Richard, as well, around directors disqualification and the Act. I think this one relates to the COVID bits and bobs that were happening, well, 2 years ago now, I suppose. Is the Rating and Directors Disqualification Act time-bound? Over to you.
Sorry, just struggling to take my mute off. So the director disqualification process, they have 3 years from the date of the insolvency of the business to bring director disqualification proceedings against you if you are involved in the management of the company and they can establish that it's in the public interest for them to do so. In terms of the dissolved companies, the period is the disqualification part of the process remains as things stand at the moment the same. Having said that, it's a relatively new piece of legislation. It's therefore potentially yet to be tested in terms of its effectiveness and its actual through the courts, but that is the current position. Yeah.
Okay, thank you very much, Richard. Moving on, I think the next couple are going to be for Dan, so hope you're still there, Dan. Sue, thank you very much for your question. And this is relating to who else can bring a claim against a director other than HMRC and the Insolvency Service. And I mean, it's a big question. You know, how is this done, and how should directors protect themselves? Dan, can we bring you in, please?
Yeah, Sue, you asked the question just as I was starting my presentation, so I'm hoping that I answered some of that. But I'll say, yes, shareholders can pursue directors, but it's very limited. As I was saying, I mean, it's public policy, really. If a shareholder who fell out with a director had a legal claim, in most cases, then the courts would be absolutely cluttered. So there is a limited amount of rights that shareholders have, because you have to realize that the director's relationship is with the company. And so actions against directors are generally by the company. Shareholders can, of course, influence the board, they can make resolutions, etc. So the shareholders have a right through their ownership of the company to influence the company's behavior towards that director. But so in answer to your question, it's very limited that shareholders have direct rights. These are reserved to things like breach of fiduciary duty, to negligent misstatement. So a shareholder relied on the words of a director and they were entitled to do so, and they suffered direct loss. So that might be a negligent misstatement claim. You've got breach of trust, you've got breach, as I say, breach of a fiduciary relationship. So it's limited. It's possible. Certainly, it's something which a director can insure themselves against, because D&O insurance generally does cover shareholder claims. So it's acknowledged as possible, but it is limited. Shareholders really should be looking at changing the board and pursuing a director through the remaining officers in the company, because that's the primary relationship and the primary route to litigation against directors. I hope that answers the question.
Thank you, Dan. Thank you very much. I'm just going to stick with you for the moment, if that's okay, because Brian's raised another question, which I think is for you, Dan. It's around reporting fraud, and if that can be followed through under criminal law. Is that for you? I think it is. Is that one you can pick up?
Reporting fraud. Well, fraud should be reported to the board. So whoever's reporting it, perhaps they're another director, they should whistleblow. There are rules and there are rights for whistleblowing situations. But if it's fraud, it can be criminal. It can lead to criminal prosecution. So there are situations where you might want to go to the police. It's very difficult to say what you should do with any particular fraud, because I don't know what the fraud is. But generally speaking, I come back to my first point, which is that if there is a director who is acting fraudulently, I think that the other directors need to know about it and they need to take action. And the shareholders should be promoting those other board members to do so. But in other circumstances, perhaps it is one for the police to become involved in if it's criminal.
Thank you, Dan. I think that looks like a very specific case that Brian has picked up there, because he's mentioned bank statements and forgery. I just wonder if John has anything to sort of any insight onto those types of issues around how the wider board should deal with any fraudulent claims and them dealing that as a collective. Is that something you can chip in with, John, at all?
Yeah, happy to. One of the big elements there that comes through is the whole issue of culture. Do we actually have a culture on our board where it's safe for people to bring bad news to the board? Or do we have a culture that doesn't encourage that? Dan's touched already on the very significant protections for whistleblowers, but we still have in many of our organizations a situation where being a whistleblower is a career limiting event. And that tells us something about the culture. So I think it comes back to the board's role in culture and the culture of the board itself. Is this a safe place to bring bad news, or is it just a board that operates on the good news channel?
That's great. Thank you very much. And just the last one we're going to pick up from Brian. In fact, he might have raised another one, but this one in this sequence, and I think it comes back to Richard, where a director is disqualified, yet they set up a new personal service company in the spouse's name. How is that reported and unwound? I think that is one for Richard.
Okay, so if you are disqualified as a director and you set up another business effectively doing the same thing, I'm assuming from the question, but you put your wife in charge, that's a fairly common route for directors who are disqualified to try and get around the whole process. The issue with director disqualification and the being caught acting as a director effectively, even though you've been disqualified, is a question of manpower. The Insolvency Service doesn't have the manpower to double check that everybody who's been disqualified is not acting in breach of that order or undertaking. However, having said that, most of the people that get caught breaching those orders and undertakings are caught because of the fact that creditors, people involved in the business, general members of the public, or whoever will, to use a phrase that's been mentioned just previously, whistleblow. So they will phone up the Insolvency Service and they will tell them that so-and-so is acting as a director or acting in the management of the company. So the fact that you put your wife in charge may not actually save you ultimately from being found out. The key thing, effectively, is if you are involved in disqualification, then either we act in a way that gets you off the disqualification, or we act in a way that allows you, under a specific order from the court, to be a director of that specific named company for the period of your disqualification. If we do that, then you don't need to involve your wife in another business, but effectively run it yourself, with the consequences that that could have. Hope that answers the question.
Great, thank you, Richard. And I think a slightly easier one, hopefully for you now as well, from Sheila McCann. Thank you, Sheila. How can we find out if someone has been disqualified?
You'd think that would be an easy question to answer. Oh. However, sadly, no. So if you go onto Companies House and you type in the name of the person, there is a tab above it that says disqualification. If you click on that, or even if you just go in and you type in a name, it will come up with if they are disqualified or not. The other way of doing it is to search on Google disqualified company directors, and then there is a register that you can go onto through the Insolvency Service website. The issue with that register, just so that you're aware, is that they update it on a rolling basis. So they are there for a period of time and then they drop off that register, or being visible. They don't drop off the register, but they drop off being visible because of the numbers of people that are disqualified on a regular basis. But those are the only two real ways of doing it.
Great, thank you very much, Richard. I hope that answers your question, Sheila. We've got 5 minutes left. I think, have we just had one more pop in? No, just saying thank you.
There's one more comment from Brian that I think it's worth touching on, because he's clearly having a bad time, or has had a bad time. And he said that it's very interesting to hear of the theoretical legal pressures on directors, but his experience is that bad actors continue to operate without criminalisation by High Court judges. And his advice is therefore not to rely on the law, but to move on with positive business growth plans if you can. And I think it is worth coming back on that, because you can rely on the law. There are remedies. If people do bad things, there are ways of them being found out and remedies being available. It's not always very easy, and it's not always without cost, whether that's financial or time or emotion, whatever it might be. But it sounds like a very sad situation there, Brian. And what I'd quite like to do is give you some reassurance that that doesn't have to be the case. There are ways of dealing with bad actors in this corporate sphere that we're talking about.
Thank you, Kathryn. And thank you for everyone who's joined the call today. I hope everyone's found that really useful. I just want to quickly thank everyone again for listening, and all of our speakers. I'll just pass over or back to John O'Brien from IoD just to close, I think, and say thank you to everyone. And we will be circulating the slides to all of the attendees today. That will have all of the details and contact information of our speakers. As we've already said, if you do have other questions for them, they'd be delighted to have informal chats with you about how we can guide you through any particular circumstances. So yeah, that's it from me. I'll just hand back over to John for closing remarks, I think, if that's okay.
Great, Scott, thanks so much. And thank you so much to the Rix Kay team, and also to John from Integrity Governance for that. Absolutely super, if a bit scary in places, but also reassuring. So thanks so much. And also thanks to Leslie, Janine and Ola from the IoD for sponsoring this. And thank you everybody for joining and for your questions. As Scott says, and I said at the beginning, we will send out the materials and the recording and also the answers to the questions. We didn't get to all of them, but thank you all for participating, and have a great afternoon. Thanks very much.